Hello, everybody. Welcome to tonight's show of the Pro Se Survival Show. I am Don, and I am going to get started here in just a few minutes, and we're going to go over a whole lot of different things. Tonight's show is going to be specifically about what it means to be pro se and the risks of representing yourself, and it's going to be quite the lecture. So grab a pen and some paper and be ready to take some notes. Um, Let's see here. I just need to get some chat set up so I am ready to rock with you all. Okay, everybody, I have got my Windows set and we're going to go ahead and get started. If you have a question, go ahead and post it in the chat and I will be sure to answer it when we have a break in the lecture. All right, first and foremost, to all you dads out there, I know that it's a struggle in family court. Family court is a war zone for not only us dads, but in particularly us at dads. It always seems like the odds are kind of stacked against us, and that we, even if we are winning, and I use the term win very, very loosely. I don't really find anything in family court a win, but really. If the odds feel stacked against you, then chances are it's because um, things aren't things aren't being presented correctly, or we're not able to handle ourselves correctly. So we want to make sure that we're doing all of that stuff. We want to make sure that we're handling ourselves correctly, and we want to make sure that we are listening to the judge when the judge is talking, when they are giving us orders, when they're reading their orders or issuing their decisions, stuff like that. We really want to be paying attention to that stuff. I do need to say that this is not legal advice. I am a freelance paralegal. I'm not your lawyer. The content is for education purposes only and may or may not fit your situation. Every rule in every state is different, and you need to make sure that you are checking the rules of your state. If you ever have any questions or you ever feel like you need more help, then I strongly, strongly, strongly urge you to go find an attorney and have them represent you in the case. There will be an episode later on in our streams, not tonight, but in a different stream, in which we will go over how to hire an attorney, somebody who's going to be effective for you and somebody who's going to be working for you. So please join in for that one as well. Tonight's focus is going to be being heard, the risks of self-help, and bouncing back after some bad things happened in court. Just because you had a bad day in court, just because things didn't go the way you wanted them to go in court, doesn't mean that you can't get back on and you can't jump back on the winning side of things, and you can't go and do the things that you need to do to better prepare yourself for the next hearing or the next motion. Um, We are dads strong. Just because we are dads doesn't mean that we are alone. We are out there fighting together. I am a big part of the Dad Supporting Dads movement right now on TikTok. And if you are not involved in that, then please go out and jump on that train as well. All right. So the pro se mindset. This is what you need to know about yourself. Okay. What does pro se mean? Pro se means that you are acting as the attorney of record for yourself. Okay. That means you are the lawyer. You are doing everything that the lawyer needs to do for yourself. Okay, that means you will be responsible for collecting and presenting all of your own evidence. You're going to be the one that's responsible for presenting that evidence to the judge, and you're going to need to do that evidence, presenting that evidence in a very specific way, so the judge is legally bound to admit that evidence into the record, and then therefore they can actually consider that evidence. Um, you need to be ready to do any direct examination of the other party, of your own witnesses, of even of yourself. So generally, a direct examination of yourself, which is the process of asking yourself questions, essentially, is going to be a statement that you write out to the court, where you take a moment, usually a couple of minutes, to really present your case specifically to the judge, and you express to the judge that, hey, this is what my motion is about, or this is what the other party's motion is about. This is why I object to it. Things of that nature. You are the attorney. You are your own attorney, and the judge is going to give you no leniency as to you not knowing the law. Okay, you need to be prepared. You need to know exactly what you're doing. So that is going to be heavy research. It's going to be you going out and doing the things that you need to do to be prepared for this stuff. Hitting the law libraries, hitting those local resources that I hit last week in the stuff, which is going to be up on YouTube here at the end of tonight. We should have that fully uploaded up to YouTube. So. Objectivity. So this is part of that mindset again. Objectivity beats emotion. And what I mean by that is the judge decides on facts and law. Okay. They are trained to keep their own emotions out of it. I mean, let's be frank. We don't want the judge to really be getting emotionally attached to our case. If they're getting emotionally attached to our case, then it's going to be a very biased case. They're going to become emotionally attached to one party or the other. If they become emotionally attached to you, that's great, but that's kicking a lot of objectivity out, and they don't generally do that. So what you need to be doing is you need to be understanding that you are presenting facts and law, not who hurts more. Okay, it's not about her hurting more, it's not about you hurting more, it's not about who created who the most pain or anything like that. Honestly, all of your actual personal differences, the things that happened in that relationship that ended the relationship, that's water under the bridge. That's done and gone. We're not on that anymore, and we're not dealing with that stuff anymore. That's why you're in court now, is because those things have destroyed the situation so much that you want a divorce, or you are broken up and now you're in a parentage situation where you're trying to establish parentage, or you're trying to establish legal parental rights and stuff like that. So you need to be ready to um, present the facts without emotion. Okay, objectivity beats emotion. Documentation is your oxygen. What I mean by this is you need to be documenting everything that happens. Okay, I don't care if you had the best conversation with your ex in the entire world. Okay, we just sat down and talked about X, Y, and Z, and she was on board, and we had a great conversation, and I think I still love her. You know, I don't care what it is, any of that stuff. You need to be ready to document that stuff. You need to be ready to document the bad stuff just as much. Okay, if there was a bad transfer of contact time between you and mom, then you need to be ready to document that. And by documentation, I generally mean writing all of this stuff down in like a log book or a journal or something of that nature, so that you have that information ready for court. It shows the court that you were prepared. It shows the court that you were doing what you needed to do, doing your due diligence, and that you are trying to remember everything as factually as you possibly can. And that's why you're documenting all of this stuff and you're keeping all of this stuff written down. Some people like to record things and stuff like that. You got to be real careful with that stuff. For instance, I live in the state of Florida, which is a one-party state, so I can't video record. Well, I can video record anybody I want as long as it has no sound, but I cannot sound record. I cannot record any audio of another person without their express consent. So if they if I don't have their consent and I'm just sitting there trying to secretly go through and document this stuff through video and audio, then that's going to be no bueno when it comes to the court. It's not going to be admitted as evidence. Again, one-party states, you got to have both, or two-party states, you got to have both parties. If you're in a one-party state, then you only need to have permission from one side. So you only need to be providing the permission yourself. Vermont is a one-party state, so they would be a state in which you don't need to discuss with the other party whether or not you're going to record them and stuff like that, but you still need to be able to lay a foundation for that recording in court and stuff like that. So documentation is your oxygen. Basically, the way I say it is, if it's not in writing or admitted into evidence, it never happened. It didn't. It doesn't exist. There was nothing there. You're not going to have that evidence to prove anything. So your journals and your documentation can absolutely, if you're keeping a spreadsheet of every single little contact that you have with the mother of the other side, then you can absolutely 100% bring that in and bring that as evidence, as documentation of what your recollection of the situation is. All right. Know your standard of proof. So standard of proof is, everybody has heard it in criminal court. The standard of proof in criminal court is beyond a reasonable doubt. That's a very, very high standard that is placed on a jury, and it's got to be beyond reasonable doubt that they prove you guilty in a criminal trial. For most family court and civil court issues, it's going to be a preponderance. Preponderance of the issues is going to be evidence. A preponderance of the evidence shows that this is what's going on here, and this is the situation that we have at hand, and that's what the judge is going to use to start making their decisions and base their decisions on. Is, again, a preponderance of that evidence. That evidence is you present to them, that the other side presents to them, and how it all plays out. Okay, it's all about convincing the judge. It's all about persuasion in court. It's all about showing the judge, based on the preponderance of evidence, that what you are saying is true and accurate. This is how things happen. Remember, the judge is probably sitting there on the bench with the mentality of, there's three sides to every story. There's the plaintiff side, the defendant side, and then the truth lies somewhere in between. That's really what the judge is going to be looking at. That's really how the judge should be coming into any sort of court hearing that they're taking a part of, is they unfortunately have to listen to these two different sides, and then they got to find out where the truth lies in the middle based on the evidence provided by both of the sides. So if this is all making sense, or you guys got questions, go ahead and hit me up here in the chat. Type your questions in, and I will be happy to touch on them, especially if it is on topic here and it's specifically to what we're going through right here. If it's off topic, I'm happy to digress sometimes, and oftentimes I do. So. So yes, the standard of proof for most family and civil cases is going to be a preponderance of the evidence. Okay, so you're going to want to make sure that you have the evidence to present, and the evidence that you need in order to make your case worthy of the attention of the judge, and for them to, to rule in your favor. How to submit evidence in family court? That is a great question, and that comes with a big answer, and I'm not going to completely ignore that and give you zero answer on it, but it is going to be a complete topic of another episode that we have of exactly what evidence is and how you get it into family court. But essentially, every piece of evidence that you have, it's got to have a foundation. It's got to have some sort of relevance to it. You need to know what the rules of evidence are in your particular state, because the rules of evidence in every single state is different. There is a particular book that's part of the state statutes that outlines the rules of evidence in the state and how that evidence gets admitted. But generally speaking, if we're going over like a 30,000 foot view of evidence here, assuming that you know the rules of evidence and how all of that stuff goes, let's see, how do I put this into words? You're going to need to lay that foundation. You're going to need to show how that evidence came about, who created the evidence. So if it's like text messages and stuff like that, these are going to be messages that come out in either your direct examination of yourself. So in that initial statement that you make in the beginning of court, you're going to lay out all of the evidence that you have. So if you have some text messages back and forth between you and your ex, and you're wanting to present that evidence, you are going to say something like, on July 4th at 8:30 p.m., my ex, the defendant or the plaintiff, whoever they are, and we had a text message back and forth. And you're going to want to give the court enough context to show that you're not just zooming in narrowly on their one bad text that they sent to you. Okay, you're going to want to give them, a few messages before and after the text, so that you can give the court that context and you can show the court that this is a general basis of how the conversation was going, and this is the kinds of things that we were talking about. These were the things that we were doing in that conversation. And when once you've laid that foundation and you've indicated what that text message is and how it was obtained, so we were chit-chatting on this day, I screenshotted this text message and saved it for evidence, and then you are going to go and request from the judge essentially that, hey, this is that text message, this is the foundation for it, I'd like to admit this as exhibit A, B, or C, depending on how you have it labeled. Now, when you're in that, before your actual trial or your actual hearing where you're going to be presenting that evidence, you need to submit to the other party what you're going to be using for evidence. So you kind of got to let the other party know what you're using for your evidence and what your secret weapons are, per se, and telling them, both sides have to do this. So it's not really, so there's no secrets. It's unfair for either side to have any secrets and for that surprise evidence to pop up into court, and the judge is not going to allow that kind of stuff. So you need to lay that foundation. You need to explain what you're trying to give to the judge, and then you're going to just simply ask for it to be admitted. If you have gone through the proper discovery channels and you follow the judge's timelines for when discovery needed to be complete, like I have a hearing myself tomorrow, and the judge gave each party 7 days to submit all of their evidence prior to the hearing. So I had to have all of my stuff sent and into the court docket, as well as served on the other party by last week. If I didn't do that stuff with a list of all of those, not just the exhibits themselves, but a list of all of those exhibits that I'm going to be filing and how I have them labeled, then essentially the other party can file a motion or object to the stuff there in the hearing and say that that the information wasn't disclosed to them, and things of that nature. If they can show that it's prejudicial to them, or if they can show that it's going to have some harm on them, then the judge is generally going to exclude it. Now, before I'm going to kick down here on the evidence and jump back into what we're talking about today. But one last thing to say on that stuff is that, there it goes. It was there, and now it's gone. The rules of discovery are very important. The rules of evidence are very, very important, and you need to disclose everything prior to the hearing. Oh, that's what it was. Just because you have a hearing doesn't mean that you're going in and presenting evidence at that hearing. So let's say you have a status conference, okay, or something that's called a calendar call, or described as something of that nature. It's basically just where the court is checking in with the two parties to find out where they are. That's actually generally where you're going to get these deadlines and these discovery deadlines. Is the judge is going to have a status conference or a pretrial hearing or something of that nature, and they're going to tell both parties, hey, you have until 2 weeks before the trial date, which is X. You have 2 weeks before then to submit all your evidence and have it handed into the court, or you have a week before. It's all going to be submitted a week before then. So just because you have one of those hearings or you have a hearing coming up doesn't mean that you're bringing all of this stuff into you and setting it down on the table and being ready to present it to the judge, because a calendar call, a status conference, or a pretrial hearing is not the place where we're presenting evidence. That is just the court checking in on both sides to find out what do they need to do to be ready for trial. For this case to be to move forward and for us to be ready to sit down and actually hash these issues out and take evidence, what do we need to do? That's a pretrial conference or a status conference or a calendar call, as they're often described in some of the different court systems. Does that help answer your questions? I hope it does, RR. If not, you can go ahead and add some more questions in there if you have them. All right. We went over the know your standard of proof, the essentials the court needs to hear from you, okay? Notice of hearing in the motion. This puts the issue on the docket. Okay, this is something that's usually issued by the court. The notice of hearing is issued by the court usually after they receive a motion. Okay, so you file a motion. For example, I filed a motion to modify child support a few months ago. That's what my hearing is on tomorrow. So I put out a motion to the court and I said, hey, well, actually the Office of Child Support did, but they put out a motion to everybody, and then the court says, okay, we have your motion. Here is a notice of hearing. This is when your hearing date is going to be. And on that notice of hearing, they gave us just what I was just talking about, those deadlines for our discovery process. So they said 7 days before this hearing, that's when you submit everything. You need to have X, Y, and Z submitted to us in order for it to be on the docket. Now, if the other party doesn't do that stuff or you don't do that stuff, then either party can go into the judge and file and make a motion that's called a motion in limine to exclude particular evidence. So they can exclude financial documents if you didn't file them in time. You can exclude education records if you didn't file them in time, doctor's records if you didn't file them in time, stuff like that. So this way then, that's a preemptive to the other party. If the judge grants your motion in limine, that's a preemptive to the other party to say you can't say any of this stuff and you can't present evidence on any of that stuff. So if they do, you just simply, the motion in limine would be something that would be filed or that would be stated either orally or filed just prior to the hearing or once that deadline is passed. And then if they try to submit evidence in that stuff, you would just say, objection, Your Honor, this violates rule X, Y, and Z of whatever state you're in. And then you would say, this was on my motion in limine. And then the judge from there is going to make a decision on that motion in limine, and they will make decisions on your objections as they come forth. Okay. Every court has a captioning. Let's see if I can pull this up without major distractions here. Snippet here. And let's see if I can pop this in here without any massive problems. Just so you guys can see it. Oh, I cannot. It's not right there. So basically, I'm a visual guy, and I know other people out there are too. So essentially, the captions is just the very top of any document that you're going to file in court. And essentially, what it is at the very top in the header aspect, you're going to put the state in which you're in. So state of Vermont, state of Washington, state of California, whatever, state of Florida, whatever it is. On the other side of that header, you're going to put in the name of the court that you're in. So For me in particular, it's a superior court. Other courts call it a circuit court. Other court other courts call it something different. Um, and then you're going to put what county court it's in, and then you're going to put in what division you're in. So for my cases, it's the state of Vermont, the Superior Court, the county unit, and then the family division. So that's at the very header of the stuff. And then the rest of your caption is going to be the name of the parties, usually stacked on top of each other. So in my situation, it's Don Angelano versus the defendant in my case. And then just to the right of that stuff, off to the right, is a docket number. Most of these captions can be found on the court website that you're looking for. You can look at either their forms. If you're going to be writing up your own motion, which is what I do, I generally don't use a lot of the court forms. But if you are, you can go ahead and throw your, or you can go ahead and onto your court district website and look at the top of their pages, and you'll see their captions. And that's the captions that you use on pretty much every filing you do. And then below the caption is the title of your motion. And then below that is all of the information that you're going to include in your motion. Okay, that can include an affidavit. That can include your law arguments. All of that stuff are going to be included in there. Affidavits and declarations, those are, so an affidavit is and declarations are something that you type up yourself or you write up yourself, and it becomes a sworn statement or something that's under oath. Nowadays, courts seem to be stepping away from and developing their own rules to be able to have verified motions or verified affidavits. Because of COVID-19, they were trying to find ways of not sending people out into the world and getting notary publics to notarize all of their documents. And so they came up with this new verified motions or verified affidavits, in which just includes, and you have to check your local rules again for this stuff, but it includes what the local rules are for that verification. There's usually a paragraph or something that you have to put in there and sign as being under oath, etc. So declarations are going to be specific things that you're declaring to the court, specific facts that you're declaring to the court as true and accurate. They need to be firsthand knowledge. Okay, so here's touching back on that evidence stuff, which is important when it comes to evidence, is first-hand knowledge. It has to be something you know. Unfortunately, one of the biggest walls that dads come across in family court is, well, I was talking to my kid, or my kid said to me during contact time X, Y, and Z. That's hearsay. It doesn't matter who it comes from. It doesn't matter who says it. It doesn't matter if they say it directly to you in that situation. If your child is looking at you and saying, well, mommy, blah, 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 and mommy, blah, 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 that's all hearsay stuff. And you run into a really, really sticky situation when it comes to your kids telling things to you and you trying to use that stuff in court. The first and foremost is family courts hate to put kids on the stand. Okay, they hate to pull them into chambers. They hate for a judge to sit there and question them. They hate to put them in the middle. They hate to make kids feel like they're tattletaling on another parent, or that they are that they're telling on somebody. Okay, or that they're against their other parent. It's really, really traumatizing to the kids. There's plenty of evidence out there on the psychological effects of family court and divorce on kids. So they just don't like to do it. That's why we have these folks that are called guardian ad litem's that are there to represent the best interests of the kids. They have those conversations with the kids after they've got, they're supposed to have good training. They're supposed to be trauma informed. They're supposed to be there looking out for the best interests of the kids. And so a guardian ad litem would be able to come in and address the child, talk to the child about what's going on, what they're feeling, different situations, stuff like that, and then they put that stuff all together in a report that goes to the judge, and the judge then takes that pretty much as the point of view of the child. and the guardian ad litem will make some recommendations in there as well. There's other things too, other folks out there that are called parenting coordinators and stuff like that. That's a little bit different than the guardian ad litem. They are there to try to work between the parents and come with a reasonable plan. What's again still focusing on the best interest of the kids, because that's exactly what the court is going to be looking at, is the best interest of the kids. So that those are the things that the parenting coordinator is going to go for. But again, affidavits and declarations, keep it to firsthand knowledge. Don't get into the well, my girlfriend's best friend came to me and told me that she saw blah 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 blah. If you ever have a conversation like that with anybody that's associated with your ex, and they're like, "Hey, I'm really concerned about your child with your ex because these types of things are going on," you need to have the conversation with them to say, "Hey, I truly appreciate you coming forward, and I truly appreciate you coming and talking to me about this, but I really need you to make that report to DCF or CPS. I really need that report to be made officially with an agency that can investigate it." So if it's talking about abuse or neglect or anything that's reportable and that stuff, strongly ask them to make a report with the police department, or make a report with Department of Children and Families or the Child Protective Services, whatever that agency is called in your state. That varies as well. Ask them to make that report with them, even if it's an anonymous report. Ask them to make that report with them. Trust me, you want that third party agency coming in as a neutral factor in the whole thing, to be able to set things right. And I will get into just a bit about DCF and what you want to do if DCF comes to your door. If DCF knocks at your door for any reason, everybody there's a lot of controversy around this, and a lot of people will probably argue with me on this fact, but bottom line is if you have nothing to hide, don't make it seem like you're trying to hide something. Okay, if DCF or CPS comes knocking on your door and they're saying, "We've received a report of X, Y, and Z, we need to sit down and talk to you about it," blah 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 blah, there could be a couple things going on there. They could be investigating the other parent. Okay, and they could be just coming to your home because it's part of the process. It's part of the process of making sure the child is safe and that they're in safe homes when they're doing their investigations. I've had CPS knock on my door on more than one occasion because of reports against my ex. And those reports resulted in them wanting to visit both homes to assure that both homes were safe places for my kids to be. So when they came knocking on my door, I was never, ever defensive. I never looked at them as, "What the hell are you doing here?" And get away from my house and stay away from me. And I have nothing to say to you. I'm invoking my Fifth Amendment right. I've never done anything like that with any sort of DCF worker. So I have always been of the mindset, I have nothing to hide, so I'm not going to make it seem like I do have something to hide. I have always opened my door to DCF. I have always let them come into my home, sit down on my couch, offered them a glass of water, sat down and discussed with them what was going on. I have found in that stuff that DCF has been very, very cooperative with me. They have helped me a lot in some of my own family court struggles and family court battles, and I have been able to take that stuff and use it to my advantage in the court settings, and I have been able to take their information and bring it to court and present it as evidence to the courthouse. So again, don't try, if you can be, and it's reasonable, definitely don't give up all of your rights. If CPS is really pushing on things and making things bad, then I don't know what that sound was. Then definitely don't let them push you around, okay? But that doesn't mean that you want that to push them out just because they're there either, okay? Weigh your stuff out. If you do have an attorney, or you're thinking about getting an attorney, and DCF shows up at your door and they seem a little pushy or they seem a little obstinate against you, then at that point in time, it's probably a good time to really consider hiring an attorney to protect all of those rights. And you can express to them at that point in time that I have no problem talking to you, but I am going to get an attorney, and I'm going to wait to make any statements to you until I get that attorney. So here's my contact information. Can we schedule another time in a couple of weeks? And by that point, I should have an attorney for you. They're not going to like it per se, but they should accept it, and they should accept it as part of as part of your rights and what you're trying to express. Okay. Financial affidavits, this is required for all child support issues, okay? So you should be filing this with, if you're filing for a divorce, you should be filing this with your initial divorce paperwork, your financial affidavits, so that they can issue a temporary child support order. This is going to be coming from both sides, and if the other side does not submit their financial affidavits at that deadline that the courts gave, then this is something that you would move to be a motion in limine, and would be something that you would object to at the moment that the stuff is trying to be presented. So if their attorney's like, oh, here's the financial affidavit, Your Honor, blah, 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 you just simply object, Your Honor, this was part of my motion in limine, this violates rule X, Y, and Z. You established in the pretrial order. This is what needed to be. This was the deadline, and I object because I didn't have time to look this over, and I'm not prepared to defend against it. So those are things that you would be able to object to as evidence as well. This does become evidence. You're going to want to update this if anything changes at all. Okay, so if you got a 50 cents an hour raise between the month that you filed your petition for divorce or your petition for parentage, and and 2 weeks later you got a raise, and a month later you're going into court, you're going to want to make sure that you file a new financial affidavit, telling them what that change is. Okay, so let them know what the change is. Let them and be filing that anytime there's a change in your financial affidavit. The reason for that is because, again, affidavits are sworn statements. Any deviation from that affidavit without you properly correcting it is going to kill your credibility, and credibility is key. It is like the number one thing in court, and the more they start to see mismatches or things conflicting or things not adding up, the more that etches away at your credibility, and eventually they just don't believe you anymore, and they can't take anything you say as fact. So now, even under oath, when I've sworn to tell the truth, the whole truth, and nothing but the truth, once we get into that I have no credibility stuff, then that has been chipped away, and the judge says, well, I don't really know what you're saying, and they have been telling me the truth all along with no deviation. If you're in a he said, she said kind of situation, they're going to be leaning towards the person that that has the most credibility in it. Okay. Proposed orders. I'm a little caught on this as a pro se litigant, because I think it steps on the toes of the judges and the other attorneys a little bit. They're officers of the courts. They're really the ones that are going to be issuing the orders, and they're really the ones that have kind of established this proposed orders aspect. But that's not to say it's off the table for a pro se litigant either. And a proposed orders is just going to be using that court defined caption, okay, the thing we were just talking about earlier, where it's got the type of court that's listed at the very top, then it's got the parties, and it's got that docket number in there, it's got the title of the motion and stuff like that. That caption, you would put that at the top of a proposed order. You would issue in your title, proposed order for modification of child support, or proposed child support order, okay, or proposed contact schedule, or proposed legal rights and responsibilities, or proposed child's rights and parental rights and responsibilities, and or something of that nature. You would put a proposal in, and you would write it all out very, very specifically and court-like, to the point that you have laid out every single aspect of whatever it is the order. If it's a child support order, you've laid out what that child support order is going to contain, and it falls in line with the legal formats that the court would be generally using to issue that motion, or to issue that order. Now, does that mean that the judge is going to just sign off on it because you put the signature line in there and gave them a spot to sign off on it? No, it doesn't. You're going to want to give that proposed order prior to your hearing, and what that does is that gives the judge and the other attorney time to look through that order, and they're probably going to be making notes on your proposed order throughout the whole thing, and then they'll write up a cleaned up version. Or what I've been seeing a lot in courts nowadays is they tell the attorneys to go back and write up the order and then submit it to the court, and if it falls in line with what the court ordered, then the judge will sign off on that, and then it gets shipped out to both the parties. But proposed orders isn't really an option optional thing. And if you really want to get into specifically outlining what you want that proposed order to look like or what you want that order to look like in the end, you can submit this to the judge just before your trial date, and they'll skim through it, they'll see it, and they'll know kind of where you stand and what specifically you're looking for in an order. And that might help you, especially if you filed the motion. That might help you in your motion and getting the order to fall in line with what you want. The exhibit list, we talked about that a little bit. The exhibit list ensures that the evidence is admitted, and it's a file and exchange by rule deadline. Okay, it's outlined. It's a straight list under that captioned heading, indicating what every exhibit is and a brief description of it, so that the court knows what the exhibits are, what their label is, A, B, C, 1, 2, 3, whatever that stuff may be. It's all laid out and it's all there for the judge to see specifically. That is going to be required to be filed with any evidence that you are going to submit to the court. Okay, so along with the exhibits themselves, if they're text messages or documentation or something like that, you're going to want 3 copies: a copy for you, a copy for the other party, and a copy for the court. The copies for the court are going to get filed with the court. You're going to either go down and drop them off at the court clerk's office and give them the docket number and file it all together, or you're going to e-file it, and you're going to file everything electronically in the e-file portal for the court. Let's see here. Rule checklist. You're going to just want to go through your own setup of all the rules, the different court rules that you have to follow for whatever you're seeking out for your motion. If it's your petition for divorce and you're looking for it all together, this is going to be the big research aspect of everything. These are going to be every single rule that pertains to family law within your jurisdiction. And then you're going to want a checklist to make sure that you are following all of those rules, the discovery rules, the evidence rules. Make sure that it's all there and that you've covered all of your bases, so that when you get into court, the court isn't looking at you thinking that you are completely incompetent and wishing that you had hired an attorney. Okay, the more prepared you are going into the court pro se, the better response you're going to have from the court. If you are prepared and really put all of your ducks in a row and you dotted your I's and you crossed your T's, then the court is going to respect that, and they're going to give you the time to express everything. Otherwise, you're going to find that the court is cutting you off, shutting you down, and you're going to feel like you've got nothing going for you. Okay, and that seems to be a pretty strong pattern for a lot of us men here going through this stuff. Okay. So what happens when leading into to your motions of whatever? Okay, let's say that you have filed a motion to modify and we'll say that you're in your motion to modify, you're in the actual motion hearing, both sides are there to present evidence, and the judge and you move to object something, and you move for a piece of evidence to not be admitted, and the judge says that you're overruled, or they effectively deny your motion to exclude what the other party's trying to push. If they object to it, or if you object to it and they deny it, or they deny your motion outright at the end of your hearing, things that you don't want to do. Heavy sighs are a big no-no. Don't let the court hear that you're seriously disappointed. Don't roll your eyes at the judge. Don't try to start asking the judge for a full-blown explanation there on the record as to why they're denying your motion. Don't start conflict with the judge. Don't start to be argumentative with the judge or anything like that. Okay, you need to be ready to accept the fact that they might deny your motion. Okay, you might lose that hearing. It doesn't mean it's the end of the road. It just means that particular chapter is closed for right now. Depending on what particular chapter you're talking about, that may close the door for now. And you may have to wait until the next cycle comes around. Like child support has rules as to when you can refile, even custody and visitation and contact time and stuff like that. They have different rules that you can file for before you can file for a motion to modify. Some places have time limits on that stuff. For child support, some places have a percentage of change before it'll trigger a child support order change. So and those are some of the, just stepping back for a second, those are some of the rules checklists that you need to be informing yourself on. Am I within those time frames? Am I outside of those time frames? Did I do everything okay? Did I admit everything to correctly? Did I file this timely? Things of that nature. Um, so it is really, really important to stay calm. It is really, really important to stay neutral, and it's really important to stay right in that professional tone. Okay, I didn't get what I want. We're going to finish listening to the judge out. Once I leave the courtroom, I'm going to call up my best friend and I'm going to tell them all the things that the court did, and that's where I'm going to voice and I'm going to vent, and that's where I'm going to say all the things that I have to say to the judge. Okay, but the judge doesn't want to hear them, so don't put yourself in that situation where, again, you start to chip away at your own credibility because you're challenging the judge and you're yelling at the judge or you're arguing with the judge because they've issued their ruling and you don't agree with it. Okay? Instead of doing that, politely ask, Your Honor, may the order include specific findings for your ruling? Okay? This is going to ensure that the judge puts an order, when they put their order out, that they specify why they issued it, okay? Why they found things the way they did. This is going to help you if you want to appeal it. This is going to help you if you're trying to appeal the decision to a higher level, or if you don't really have grounds to appeal, and that's kind of a fruitless cause, it will tell you what steps you have to take for the next time, okay? What you're going to do in the next hearing that is going to create hopefully a stronger case for you, okay? Because you've learned from the last experience, you're pushing forward in this new experience. Now I've got what the court ordered in the last time, I know why they ordered it, and I've covered my grounds in this new motion within the deadlines, okay? So notice for deadlines, you're going to need to check your local rules. It's usually, for a motion for a rehearing, it's usually within 10 to 14 days. This is also can also be construed as a motion to reconsider. Again, usually within 10 to 14 days, sometimes within a week. But again, check your local rules, okay? This is not legal advice. I don't know what the rules are in your state. I don't know how your state operates with these. Some motions don't even get the opportunity to be reheard. They don't even have, a judge doesn't even have the authority to reconsider their ruling on that particular thing. So usually for a motion for reconsideration or a rehearing, you got to be able to show that there was something that was left out that should have been known at the time that wasn't, or you need to be able to show on the record that the judge really, really messed up and you're giving them an opportunity to fix their mistake. That's really what those things are for. Notice of appeal is usually within 30 days of the issuance of the order. So if it's an appealable decision, again, check your local rules to find out if the decision is appealable. Appeals gets into a whole new ballgame of the legal world, and I definitely strongly advise you to find an attorney to at least give you some advice and give you some consultation time to sit down and run through your case with them, run through the orders that the judge gave you and how everything ran, and then talk to you about what you have for an appeal, for grounds for an appeal, and whether or not it's even worth it. Definitely talk to a lawyer about that stuff. It gets really, really sticky with appeals because they only hear very specific issues. Okay, and it is not a place to rehash all of the things, all of the questions of fact, or all the things that the judge decided in the back. At the lower court, it's not a spot for them to rehear all of that stuff. It's really a spot for them to look at the legal issues, the laws behind your motion, and the laws behind what the judge issued for their decision, and whether or not the judge made a mistake when they issued that ruling. They do not rehear facts. So if you go in there and you're trying to argue all of the facts of your case, they're not going to listen to it. You're not going to hear the Supreme Court or the appellate division of your court area is not going to hear those issues again. They're only going to decide on what might have been erroneous and how the law might have been applied incorrectly. Order transcript. If you're going to appeal or you're going to request for a rehearing, you want to have a transcript of your hearing. So either get the audio recording of the hearing, um, and get it transcribed by an official court reporter association. These get pricey. Okay, this is going to be super expensive, especially if you fall outside of the poverty guidelines. There are ways to get transcripts for free or reduced prices. If you fall in line, you have to fill out an application with the court clerk to define whether or not you are within those income means to get a reduced or no cost transcript or recording, but otherwise they are super, super pricey. You're paying by the hour and usually by the page for that stuff to be transcribed for you. So um, self-audit. This is another big step here. You want to make sure that you're checking. This is the dotting your I's and crossing your T's aspect from you staying prepared. You want to make sure that you have correctly cited all the right statutes. You want to make sure that you've read all the case law that you've cited, especially if you're using AI. If you use AI for any of this, make sure you check all of the statutes that AI cites to you. Make sure you check all of the case law that AI cites to you. You can usually do a Google search with the citation that you get from an AI generator, and put that into a Google search, and you can usually pull the case law up specifically, and now you need to go and read through it, and you need to read it through line by line to make sure that how AI applied it to your case is actually applicable. So make sure you do your due diligence there. Procedural missteps, you want to also be checking yourself on this stuff and making sure that you are following all of the procedures. Or if you missed a procedure and you didn't do what you were supposed to do, did that maybe contribute or constitute what the judge says in their denial of your motion? Is that why things got denied? Did you put the judge in a situation where they had no other choice? Their hands were tied and they had to issue an order because you procedurally were incorrect? If that's the case, then when you go back in, when you meet that threshold of time that's passed, or you meet that threshold of dollar figure, if it's a child support stuff, you want to make sure that you don't make that mistake again, right? So we want to make sure that you're getting yourself prepared and taking care of yourself in every procedural step along the way. So read those statutes, read the rules of evidence, read the rules of family code and procedure in your area so you know exactly what the court is expecting of you. It is all laid out. Sometimes it is very confusing to read because it's just not plain English sometimes, but it is every rule, everything in evidence is all there, and it's all laid out pretty specifically as to how everything goes and what you're supposed to be doing. So preparing for your next hearing. So gap analysis, we want to compare the rulings and findings to your exhibits, list what was missing and what was not persuasive. So this way then you can go and either pick up the evidence that was missing. So maybe the judge says, no, this was hearsay. If you get evidence that's kicked out because it's hearsay, then now you're going and you're subpoenaing those people as witnesses, okay? Whoever you were hearsay, if it was your ex-girlfriend's best friend that told you X, Y, and Z, then you're subpoenaing her for the next him or her for the next hearing that you have on this issue, so you can discuss that and you can bring that stuff forward, and you don't get called on a hearsay violation. Maybe you missed putting foundations up, so the judge didn't find the relevance of your evidence. So you want to make sure that you have proper foundation and that you know that you've thoroughly express to the judge why this is relevant to the case. So again, they have to admit it into evidence. Stronger evidence, subpoena school, subpoena medical or police records, line up the expert or the teacher at the affidavit. So this is big too in those rules of evidence that were asked earlier. So if you got a police report, there's two ways to get that admitted into evidence. Either A, an affidavit of business records. So you need to get something from a sworn statement from somebody who's authorized within the police department to say, yeah, this police report is an accurate depiction of what we have in our business files. And if you have an affidavit to support that, then you can submit it together with that. If in general police records, it's highly advisable for you to subpoena the police officer themselves as well. This way, then you can call them in. They're going to provide direct testimony to what they put into their report, and you can also elaborate a little bit off the report. If you just have the report itself, there's no additional questions that you can ask of the officer of, so what did you do then, or how did this, what did you interpret that as, or what did you feel was going on? You know, they can give you professional opinions and stuff like that at that particular moment. Um, Refine your legal theory. What this means is make sure, again, more research, making sure that you're doing your research. Make sure you know exactly what you're talking about and that you have clearly stated it, okay? Draft after draft after. When I write a motion myself, so I wrote a motion about a week and a half ago as a motion to join for my child support hearing. And basically what I wanted to do is I wanted to join in on the Office of Child Support's motion, and I wanted to convert that to a motion to modify because the judge had kind of hinted to that being the driving factor here. So I refined my legal theory in this whole thing, and I said, okay, I want to join this motion officially as myself and self-represented, and I would like to also make this a motion to modify instead of a motion to clarify. And hopefully what the judge does is they do enact that and they do say, okay, yep, this was filed. I accept your motion to join. It's granted, and this will now turn from a enforcement hearing to a modification hearing, and we'll take evidence on that stuff. Make sure that you're reading controlling statute and reading controlling case law. So check all that case law out, read it, make sure that you understand it. And then or the controlling statutes, make sure you read them and that you understand them, and make sure that you draft before you get to a final copy, and everything is refined, crystal clear for the court, and that there's very little gray area, or preferably no gray area. Courts don't really like gray area. They don't want to try to decide things without knowing really clearly what is going on. So mock hearing, that is great. I've got an idea about this myself. I'm thinking about creating maybe. Yay! Sorry about that. The headphones died. I'm thinking of creating like a mock courtroom where people can submit to me their cases, and maybe we have some people who have been viewers on this show before, and they come in and they act as the other side of the table, as well as we'll have a judge. And it's just going to be a place to act all of this stuff out, for you to be able to come in and voice your case, voice your motion, get some feedback on it. That doesn't really seem clear. I think we can clear that stuff up a little bit more, and make it crystal clear for the court and stuff like that. Maybe it's something that's used before you file. Maybe it's something that's used after you filed and you have a hearing coming up, so you're just trying to get yourself ready. Maybe it's used in conjunction with both. But either way, if you can kind of set up a camera like I have set up here, with all of the evidence and stuff like that you have, your motion in general, and you can just kind of act it out and play it out. Maybe you get a couple friends or whatnot that can sit there and listen to you. It'll help take the jitters out, because you're going to feel awkward as heck sitting there presenting your case to a friend who knows nothing about anything, or maybe they do know what's going on but they don't have any idea what the law is, and you're sitting there presenting to them in all this legal spiel what you're trying to prove, and they're just kind of looking at you like a deer in the headlights. But it's going to be helpful. It's going to give you a spot to be able to get that information out, and you're going to be able to hear yourself speak. Your friend can give you a little feedback. Maybe they didn't understand something completely and stuff like that. So just making sure I don't miss anything here. Um, big big, strong takeaway from this, okay, as we're starting to wrap things up a little bit and getting towards the end of the stream. If you have any questions, please drop them here in the chat. I will answer them before we jump off the air here, and then we will have another show just like this on Thursday. If you give me 1 second, I'll tell you what that is going to be on. The topic next week is going to be legal versus physical custody and shared versus sole custody. So we'll go over what all of that stuff means and what you're fighting for, what 50-50 means, joint custody, sole custody, and how all of that stuff pertains to life and custody in general. Okay. But what I do want to say here again, as we're wrapping up, is losing a motion doesn't mean that it's not a death sentence. Okay, it's not the end of the world. It is one particular motion that you've lost. It doesn't mean that it's the end of the argument by any means. It doesn't mean that you are in a situation where you're completely dead in the water and you need to give up all hope and everything is done. It is just a data point. Okay, it's a spot where you can go back and reevaluate the whole situation so you can build a better case going forward. Okay, I lost this motion, and I've lost motions. Let me tell you, I've lost emergency motions when I thought my kids were in danger and that things were terribly bad, and I really needed to get the court into this, and I really needed to get the court involved, and I needed action right now. They've been denied, and I sat there and I cried, real man tears, I'm telling you, because I thought my kids were being hurt. They were being hurt. I thought they were being hurt, but the court didn't see the evidence in the same way that I did, and so they just said, wait for your hearing. And I did. I waited 2 years for my hearing before the court finally said, hey, you're right. There's been some things that have changed, and there's been some things that need to happen here. So let's get on it and let's take care of all this stuff. So it's not a death sentence. It's just a data point. It's a spot for you to go back and look at what the judge ordered. Why did they order? Why did they deny your motion? What did they say to you? What did they say on paper as to why the motion was denied? And what can you do to gather more evidence or to solidify that evidence? Who can you subpoena? What do you need to subpoena? What do you need to do differently in order to get the right evidence in front of the judge for them to see what you're trying to say? Really, really take that to heart, guys. We're going to lose motions. We're not going to win them all. We're not going to get the court to see us on every single aspect or every single data point that we present to them. They are going to shoot us down once in a while, and we just need to be ready to go home, call up that buddy, call up that family member that you've been talking to, and vent to them, tell them everything that happened, get your emotions out, cry those tears, and be ready to stand up and get it the next time. That's really what it's all about, okay? As I said before, we are going to be covering custody basics next week. Or not next week, Thursday at 8 o'clock. We're going to be here again covering the custody basics for dads, legal versus physical, shared versus sole, what all that means, what you're asking for in court, what's reasonable and what's unreasonable. I tend to catch a lot of flack for this from other dads out there because I'm no bullshit with any of this stuff, guys. I'm going to tell you exactly how it is, and I'm not going to bandwagon with you if I don't think that you have a strong enough case to take sole custody, for instance. So I'm going to be honest. I'm not going to hold any punches. We will talk about things. If you've got specific questions about that stuff, then we'll go over all of those things specifically. But in the meantime, it has been an absolute pleasure spending the last hour and 5 minutes with you all. It has been an absolute pleasure answering your questions. RR, I think you're the longest viewer that stayed in here, so thank you so much. I appreciate it. If you enjoyed this, please share it with your friends. Please share it in the social media forums that you're involved in. Maybe you're part of the Pro Se Dad groups or anything like that. Just getting this stuff out here as it being helpful and meaningful to you would be absolutely fantastic. I super, super appreciate it, and I think you guys are absolutely amazing. I will be back here on Thursday at 8 p.m. to go through another round. The more this gains popularity, the more people we can get going in here. Thanks for that, Rose RR. That is super awesome. I appreciate that. The more people we can get out there, my man, and the more people we can bring into this, the more we can collaborate together as a team, and the more questions we can ask, the more conversations we can have, and this becomes less lecture-y and more roundtable-y, and I would really love to bring in more dads that have had this experience, that have experience to be able to be shared with everybody. So blessings to all of you guys. Blessings to everybody who stopped in and said what's up, and joined us for even just a little bit. We will be back here Thursday at 8 o'clock to discuss some more, and we will be back here every Sunday and Thursday. You can look for this and episode 1 up on YouTube. I'm going to get those up here before I go to bed tonight. I'm going to promise you episode 1 will be up on YouTube tonight. I'm finding out that the recording wasn't working here in my recording software here, so I'm going to have to download this when it's from the social media platform, and then I will get it back up onto YouTube so everybody can rewatch it. Again, I appreciate everybody. I appreciate the Rose RR. That is super awesome. That is actually my first gift ever in any of these live streams, so you rock, man. Blessings to everybody. I hope you all have a wonderful night. Happy Sunday, and we will see you all Thursday. Peace.